Hello and welcome to another crypto edition of Legal Briefs. You know, this Ripple lawsuit has really been keeping me busy, and as you may know, the SEC filed an amended complaint today, Thursday, and I will tell you what that is all about and an issue involved that is very interesting. I also want to thank all of you for watching our channel, and as the number of our channel subscribers keeps growing, I personally want to promise you that I will not give in to calls from companies that want us to sponsor them, and I will never push any products on you guys. I promise I won't do that for a quick buck. Just a moment. Corona Extra, la cerveza más fina. Welcome back, and the quick disclaimer, do not take anything I say as legal advice. If you really need a lawyer, you'd be better off hiring these two. Now everyone knows that's Julia Roberts, but super bonus points for naming the actor who played the lawyer. He passed away in 2019, great actor. Okay, so an amended complaint was filed in the Ripple lawsuit today, and by popular demand, I had my assistant print out all 79 pages, and then I got irritated at the SEC because when I file an amended complaint, I will put at the top what paragraph changed. I put in there, these paragraphs have been changed. The SEC put nothing, so when I got home, I literally had to go through all 400 paragraphs and make a note about what had been added. There are two things going on with this amendment, possibly three, but let me tell you, and then I'm going to give you kind of a summary. Now first, the amended complaint mostly adds factual details in regard to the individual defendants, Chris Larson and Brad Garlinghouse. And I haven't really touched on this before, but now it's the perfect time. In prior enforcement actions, the SEC has typically only pursued action against the issuer of the digital asset, against the company itself. While often noting specific statements or actions by the respective CEOs, the SEC rarely names individuals associated with the issuer or the distribution as named defendants. We saw that in the Kick Interactive case and the other cryptocurrency cases. It's highly unusual that the SEC names two executives as defendants, so it kind of stuck out to me. But even more unusual is that they are charged not only with a primary violation of Section 5 in offering and selling securities themselves, but also with kind of aiding and abetting Ripple's violation of Section 5. Now, the lawsuit against Garlinghouse and Larson is actually very difficult because in order to sue individuals like this, you have to prove something called scienter, which is a fancy legal word for knowledge of intent. So in other words, it's not enough as to individual defendants that the SEC prove XRP is a security. It has to also prove that the individual defendants knew it was wrong to do so and still moved forward with the sales. So this is why the fight over whether the SEC can get the opinion letters from Ripple's lawyers that warned them XRP was potentially a security is going to be a big issue. It's attorney-client privilege, but the SEC wants those letters to help them prove the scienter. Scienter, I love that word so much. Anyway, so what happened was that the SEC did not do a good job of alleging in the original complaint that the individual defendants had the legal scienter to be sued. So for example, the SEC added to the amended complaint paragraph 110, which says, quote, Larson and Garlinghouse both played significant roles in negotiating and approving Ripple's institutional sales and other offers and sales of XRP to institutional investors, close quote. So that is a new allegation that is pretty typical of the new complaint. This amended complaint was kind of heralded by the letter to the judge last week where the parties told the judge what contemplated motions were out there. That's in, I think, subparagraph 2 of the letter. In short, what happened was that the lawyers for Garlinghouse and Larson told the SEC that they were going to file motions to dismiss the lawsuit against them. And the SEC said, well, okay, then if you're going to file a motion to dismiss, we're going to go ahead and amend the lawsuit in order to try to avoid your motion to dismiss. And therefore, they got the amended complaint done, and they put in a lot more facts showing how Garlinghouse and Larson were personally involved. I still think there will be a motion to dismiss, but I think the individuals will probably lose those motions because I think there's enough facts now in the lawsuit to keep them in the litigation. And that's bad for Ripple because Garlinghouse and Larson are obviously high up in Ripple and will decide what Ripple does. And until you've been sued by the federal government, you have no idea how stressful it is. I mean, it's the kind of stress that leads to sleepless nights, tears. You can't concentrate, you can't enjoy time with your kids. It's horrible to be on the end of this kind of lawsuit, and it's going to affect what Ripple does because Brad and Chris are obviously high up in the Ripple hierarchy. So we hope they get out, but I don't think they will. I think the SEC has kind of locked them in now. But I wanted to do some quick conjecture about why they were sued to begin with, when no other individuals have ever been sued by the SEC in a crypto lawsuit. This is the interesting stuff for me. I think there are three possibilities here. First, the obvious answer is because they kept such a large amount of XRP for themselves that the SEC wants to kind of recoup or disgorge those large amounts of profits. The second possibility is that the SEC wanted to put that stress on Brad and Chris to help the case against Ripple. And this is common in federal criminal prosecutions where you'll see that they go after your friends or your family in order to put pressure on you. Or maybe possibility three, which is the most subtle, is that the SEC is devising an escape from this lawsuit for itself, one in which it can punish the owners, founders of the company, and let the company itself off the hook. Now, I wouldn't have thought this except for how long the SEC let this case go before filing the lawsuit. In this situation where where you've let it go on for 8 or 9 years before filing a lawsuit, it might be the most equitable resolution to punish the owners in the pocketbook while allowing the company itself to settle out and continue business. It makes sense to me, enforcing the law as to wrongdoers while not punishing individuals who bought the coins. Option 3 is the closest to a win-win for the SEC that it can get if it truly wants to enforce the law and protect purchasers of XRP, and it can't do it if it hadn't sued Garlinghouse and Larson. But that's all conjecture for now. But there is one more really important thing that was added to the amended complaint, and it's not obvious, but it is super important because Ripple is teeing up a jurisdiction argument. I could smell it, and the SEC does also. This was hard to catch, but look at paragraph 186 in the amended complaint, which is new, and it says, quote, Garlinghouse offered and sold XRP on at least 2 platforms incorporated in the United States and 1 incorporated abroad with its principal place of business in New York. Now, why was that added? Because a court must have jurisdiction over the matters in the lawsuit. For example, if you go to Amsterdam and you smoke some stuff over there in Amsterdam, a court in New York has no jurisdiction over you for that because you were not smoking it in the USA. You can't get in trouble for it unless you get in trouble for it in Amsterdam. But with the sales of a cryptocurrency, specifically XRP, where you have a sale and transfer of a digital asset made and logged on perhaps hundreds or thousands of nodes around the world, how are you going to prove jurisdiction over that transaction? How are you going to prove that the actual transfer occurred in the USA and that the court has jurisdiction? That simple question shows you how antiquated our legal system is when it comes to digital transactions. The courts have only recently even attempted to address that issue in the SEC versus Traffic Monsoon case, but without going into too much detail because it'll bore you to death, suffice it to say the case law is a mess, and it does open up the door for Ripple to tell the court that certain transactions may have had enough effect in America that there is jurisdiction, but other transactions didn't, and the court can't do anything with those because they were not American related enough. If Ripple wants, it can make a mess of this jurisdiction issue, and the SEC's amended complaint kind of clued me in on it and also clued me in that they're worried about it. But enough for one night. Thanks for watching, and remember that life's mistakes are just draft versions. Turn that thing around and file an amendment in your life. It's never too late.